Hello, beautiful people. Welcome to Global Happiness today. For a while now, Nnamdi Kanu has been in DSS custody, and a lot of people have been talking about the issues concerning the 1 billion naira being given as being asked as a compensation for Nnamdi Kanu, of which is the one part of the court case being won by Nnamdi Kanu's special counsel. And then, of course, Nigerians have been shouting, why would he be given 1 billion naira after jumping bail? A whole lot of people have been, there have been this contradiction between some sector of Nigerians and others. Some said he jumped bail, he is a terrorist, what business does he have being given 1 billion? And others are saying that he didn't jump bail. Okay, he did mention a lot of this, but the likes of Aloy, Ejimakor, the special counsel to Nnamdi Kanu, have decided to speak concerning this matter and give out terms what led to what, and if he indeed jumped bail or if he did not jump bail, or if he's deserving of the 1 billion naira. It is now left for you to decide after this news, because he took his time to clear the air. But before we go into the news proper to find out exactly what he's saying, that he's even bringing more controversy and more discussions online, we'd like you to subscribe to our channel by clicking on the red subscribe button beside it. You will see bell notification icon. Please go ahead, click on it to get notified as soon as we update our channel on YouTube. Let's quickly go straight into the news. Aloy Ejimakor, special counsel to leader of the indigenous people of Biafra, Nnamdi Kanu, has said his client did not evade bail in 2017. The legal practitioner affirmed that Kanu had to flee Nigeria to seek refuge outside the country when soldiers invaded his residence at Isiama, Afarakwu, Abia State, as at September 10, 2017. He further said that the judgment of Abia High Court by Justice Benson Anya on January 19, 2022, had exonerated the separatist leader. Ejimakor, that's Aloy Ejimakor, the special counsel to Nnamdi Kanu, disclosed this in a statement on Sunday. He said, and I quote him, "This press release is necessitated by the flurry of public commentaries on the 19th January 2022 judgment of the High Court of Abia State in favor of Nnamdi Kanu. Most of the commentaries have bordered on examining the latent impact the judgment may have beyond the monetary award and the apology. Of particular note is whether the judgment should directly or indirectly impact the persisting notion that Kanu had jumped bail in 2017, which was what grounded the bench warrant that was used to justify his rendition. In summary, the answer is in the affirmative. That this landmark judgment had created new legal opportunities for Nnamdi Kanu, especially as regards impeaching the bench warrant that grandfathered his extraordinary rendition. You will recall that from late 2017, I had maintained a well-publicized stance that Nnamdi Kanu never jumped bail, and that he will, in due course of time, prove that it was the Nigerian government that compelled him to flee and seek refuge outside Nigeria. This was the material issue before the court, and it prevailed. In particular, the court held that it is the view of this court that the army set out as pythons to terminate the life of Nnamdi Kanu. The military invasion of his home at Afarakwu is so notorious that this court cannot turn a blind eye to it. He deserves an apology and compensation. Additionally, the court held that Kanu has evidence proof to the Honorable Court that his fundamental rights to dignity of human person and personal liberty were wantonly or brazenly violated, and his fundamental right to life threatened by Federal Republic of Nigeria. In other words, the court held that Kanu never made a voluntary decision to flee the country Nigeria or to be absent from his trial. To this extent, this judgment has finally arbitrated the vested and false notion that Kanu had jumped bail back in 2017. Accordingly, the bench warrant upon which his rendition from Kenya was grounded has now become impeachable and liable to be vacated, thus paving the way for his previous bill to be reinstated. In June 2021, the IPOB leader was arrested in Kenya and extradited to Nigeria to face treason charges. He was subsequently arraigned and brought before Binta Nyako, a judge of the Federal High Court in Abuja, who asked him to be remanded at the DSS custody. Kanu is facing charges bordering on treasonable felony instituted against him at the court in response to his agitation for the Republic of Biafra. He was granted bail in April 2017 on health grounds, but skipped bail after disregarding some of the conditions given to him by the court. He was subsequently arraigned and brought before Binta Nyako, a judge of the Federal High Court in Abuja, who asked him to be remanded at the DSS custody. Kanu is facing charges bordering on treasonable felony instituted against him at the court he was subsequently arraigned and brought before Binta Nyako, a judge of the Federal High Court in Abuja, who asked him to be remanded at the DSS custody. Kanu is facing treasonable felony instituted against him at the court in response to his agitation for the Republic of Biafra. He was granted bail on his health grounds, and right now he's agitating for Biafra Republic. All right, but let's look at this critically and the implied meaning of what the special counsel to Nnamdi Kanu, Ejimakor, is implying. From one indication, he's trying to, there's a correlation. There are two cases now. This one has been settled. There's a correlation between what is taking place or what took place in Umuahia High Court and what is taking place in Abuja High Court and what the international community will see. Now, if already it has been established from the court in Umuahia, Federal High Court in Umuahia, that Nnamdi Kanu did not jump bail. Now, if he did not jump bail, that means that issue of extraordinary rendition or that issue of him, basing it on rearrest, that he jumped bail, that was why they had to bring him in that manner, may not hold water. And on that also, the likes of the international lawyer for Nnamdi Kanu can rest on that very quickly and do the needful. So you now see that in all the court cases, they align, they are interwoven. So if there's a win in this, it's going to have a trickle effect on the other ones, and which may change the narrative totally. And now with this win, also it clearly also means that the government, except they're appealing this, the government may not be able to stand and hold water on the issue of rearrest. It may be seen now as extraordinary rendition, which may not be favorable to the federal government, but definitely a win for Nnamdi Kanu. That's all going to wrap it up. Let's meet in the comments.